Hear ye, hear ye, hear ye. From recess, this court now sitting.
Thank you. Please be seated. We now call the fourth case on this morning's docket. That is case number 104662, State of Kansas v. Welsey A. Warren.
Christina Curls of the Appellate Defender Office for Mr. Warren. I request 3 minutes for rebuttal.
3 minutes is granted.
I'd like to focus my argument primarily on the first issue and submit the others on the brief unless there are questions. The first issue is a sufficiency issue, and it's a sufficiency issue that basically has two parts. One of them is just the regular old sufficiency issue, that there was insufficient evidence to support Mr. Warren's conviction of aggravated indecent liberties with the child, and the other one is an alternative. The other part of it is an alternative means. Just starting off with just the regular sufficiency, in order for the state to have convicted Mr. Warren of ag indecent liberties with a child, they had to prove that there was touching or lewd fondling of either the child or himself. In this case, there was simply no evidence of any touching that occurred whatsoever. The evidence that came in was that Mr. Warren exposed himself to EW, or that EW saw Mr. Warren's penis, or that Mr. Warren showed his penis to EW on purpose, but no witness testified that at any time did Mr. Warren touch either himself or the child. Without some evidence of touching, there simply isn't sufficient evidence to support a conviction of aggravated indecent liberties with the child, and there was no evidence of touching in this case.
Well, I understand your argument about touching. I think the way I'm reading the jury instruction, it kind of mixed the two elements of the aggravated indecent liberties charge. It says to establish a charge, the claim has to be proved that the defendant submitted to lewd fondling or touching of his person. The defendant submitted to lewd fondling or touching is what it says, while the actual statute requires a lewd fondling or touching of the person done or submitted to with the intent. So it's kind of mangled up that statute, hasn't it?
Say the jury instruction was a little bit confusing in itself. I think the reason that was done was because the state's theory was that Mr. Warren touched his penis in order to expose himself to the child, so he submitted to his own touching, which is why I think the jury instruction was worded that way. However, that evidence never actually came in.
Do you think you can submit to your own touching?
I don't think so, no. I mean, I know that it says touching of the offender. I think I didn't make this argument, but I would imagine that has more to do with the child touching the offender than the offender touching himself. But just even to give them the benefit of the doubt that it can be submitting to touching himself, there was no evidence of that touching. I mean, no witness testified that Mr. Warren touched his penis in order to expose it to the child. There wasn't that evidence. The only evidence was that he showed his penis, he exposed himself, or the EW saw the penis. No one testified as to how that occurred. And without that occurring through some sort of a touching, it's not aggravated indecent liberties with the child. There was no evidence that once the penis was exposed, Mr. Warren continued to touch. There was no evidence of masturbation. There was no evidence of stroking of any kind. It was simply exposure, which relates to the fifth issue, which I've submitted on the brief, that it should have been lewd and lascivious behavior as opposed to ag indecent liberties with a child. Relating to the alternative means issue, I do apologize.
Are you conceding there was sufficient evidence of lewd and lascivious behavior as it was instructed?
Yes. Yes, there was sufficient evidence of the lewd and lascivious behavior. He exposed himself.
As it was instructed?
I would have to actually re-look at the instruction. I didn't review that simply because he wasn't actually convicted of the lesser, so I didn't review it in preparing for argument today. So as it was instructed, I don't know for sure. As the statute claims, there was testimony, he exposed himself, and he did it with the intent to arouse himself. But I can't remember off the top of my head the exact wording of the instruction. With regards to the alternative means on this, I haven't gotten you a 609 letter on Brown because it just came down on Friday, but I have reviewed it. I can argue it today if you would like, and if you'd like me to submit a 609 letter as well, I can do that, but I realize with the new rule it needs to be 14 days before, so I'll leave that up to you as to whether or not you would like me to submit a 609 letter as well as my argument today.
I think we've heard from previous arguments this week that a number of lawyers are aware of the Brown decision and they have proceeded whether they filed an immediate 609 letter or not. So why don't you proceed with whatever response to Brown you care to make? Okay.
My main response to Brown is in reading it, it seemed that this court's focus was on the last section of the statute and of the instruction of the offender, the child, or both. And while I made that argument in my brief as well, I also made the argument that there was an alternative means issue with the mens rea, the touched or lewdly fondled with the intent to arouse or satisfy. My argument is, in light of Brown, that this case is distinguishable from Brown. This case is different from Brown because there are two separate, distinct alternative means, alternative mens rea material elements still contained within that section. He can either be convicted because he touched or lewdly fondled with the intent to arouse the sexual desires or with the intent to satisfy the sexual desires. And those two words have two materially different meanings. I know I defined them in my brief. Arouse is pretty much exactly as it sounds, to rouse the sexual desires. Satisfy is to fulfill those. To not just be aroused, but to actually fulfill those sexual desires.
Why wouldn't that be the intent of the legislature then, just to give options by which you can affect the means? And we're not going to quibble about whether arousal was satisfied, either one, satisfied or unsatisfied. They're both ways to commit this. That's sort of the theme of Brown.
Because the legislature provided two separate, distinct mental states which could constitute aggravated indecent liberties. It's the actual mens rea of this section of the crime. It's two separate mental states. If they just wanted to say to touch or lewdly fondle with some sort of a sexual intent in order to arouse, let me rephrase. I got lost in the language there. If they wanted to say to touch or lewdly fondle with some sort of sexual intent regarding to the sexual desires of the offender, the child, or both, they could have said that probably a little bit more eloquently than I just did, but they could have done that. Instead, they provided two separate words, two separate mental states with two separate meanings. And as Brown said, when you're trying to decide whether or not something is actually alternative means or just, I think it was
options within a means.
Yeah, options within the means, factual circumstances relating to the means.
Descriptive.
You look at whether or not whether it is to list alternative, distinct material elements. That is, the necessary elements like mens rea, actus rea, or in the rare case of causation. With the intent to arouse and with the intent to satisfy are the material mens rea elements. And there are two separate, distinct mens rea elements within this subsection of the aggravated indecent liberties charge. And given that they are two separate alternative means, the state had to present sufficient evidence of both alternative means. In this case, there was no evidence that Mr. Welsey acted with the intent to satisfy his sexual desires. Not his testimony, but a statement that came in through one of the police officers, I think it was Officer Head, was that he did what he did to arouse himself so he could later have sex with his wife. So he could later satisfy that desire with his wife. He didn't do what he did in order to satisfy his sexual desires at that time. The criminal act was simply to arouse himself. There was no evidence that he did it to satisfy himself. So we would argue that there was insufficient evidence, both because there was no evidence of touching at all in this case, and because the state failed to present evidence of the alternative means on which the jury was instructed. Like I said, if there are no other questions, I will submit the other issues on the brief.
Do we have any questions of counsel? Thank you, counsel.
And I just ask that this court reverse Mr. Warren's conviction.
If it please the court, I'm Don Scott, Seward County Attorney for the appellate state of Kansas. I have read the Brown case. I'm not sure that I understand it, but I think it's dispositive of this first issue, at least as far as the alternative means argument goes. With regard to alternative...
of it how?
Basically where it says that these are not alternative means. If unanimity is the goal, this case, regardless of all that, unanimity had to have happened in this case because the only evidence was that Mr. Warren exposed himself to his granddaughter with the intent to arouse himself. I mean, that's what the evidence was. If the jury... and they obviously believed that and convicted him of it, there really weren't any alternatives for him to choose other than his penis accidentally fell out of his pajamas while his granddaughter was present. So, I mean, we have unanimity here, whether the statute has alternative means or not.
Let's talk about the sufficiency of the evidence, though, that I didn't really see that your brief addressed it at all, as far as the sufficiency of the evidence of the aggravated indecent liberties charge. You addressed very briefly the alternative means issue, but I didn't see any response to that. Could you address the arguments that she just made?
The argument was that Mr. Warren exposed his penis, took his penis out of his pajamas to show his granddaughter to arouse himself.
And what was the evidence of that?
Well, I don't know that anyone testified that he reached in his pajamas and pulled his penis out. The jury's allowed to use common sense. He took his penis out of his pants. They obviously believed that.
And so your theory of prosecution is that it's aggravated indecent liberties for an adult to touch their own genitalia in front of a child. That's aggravated indecent liberties with a child?
Aggravated indecent liberties with the child. When you've got a 3 or 4-year-old granddaughter in your room, you pull out your penis and show it to her, yes.
And so the touching requirement, and you would agree that aggravated indecent liberties with a child has a element where there has to be a touching.
Right, and the state's theory and the argument was that him pulling his penis out of his pajamas was the touching.
So on 99% of the indecent or the lewd and lascivious cases where it's an indecent exposure by a male, all of those are then aggravated indecent liberties with a child if there's anyone that gets to view that's under age 14?
Yeah. And I don't know that every
So
time.
streaking at the Super Bowl would be aggravated indecent liberties with millions of children that may be sitting in front of the television?
No, but if you're in the bedroom with your 3 or 4 year old granddaughter and you pull your penis out of your pajamas and show it to her, you've got the touching there. Now, if you know, that's not my call whether that's sufficiency of the evidence or not. It was sufficient for the jury.
Well, it's an interpretation of the statute whether submitting to touching means submitting to yourself. Submission means acquiescence, and when you touch yourself, you're in an active mode. It's either touching or submitting to touching. And how can you submit to touching by yourself? Does that make any sense?
My argument would be we're at a sufficiency of the evidence standard. The jury's convicted this guy. Sufficiency of the evidence, could a rational person have believed beyond a reasonable doubt that he's guilty of this crime? And I think that's where we are.
What's the difference under your scenario between sufficiency of the evidence and aggravated indecent liberties? Or, I'm sorry, sufficiency of the evidence of aggravated indecent liberties and sufficiency of the evidence of lewd and lascivious behavior? What would make the distinction between exposing yourself to a 4-year-old or your granddaughter and something that would make it ag indecent liberties?
In this case, he clearly was guilty of lewd and lascivious behavior. That wasn't charged. Okay, the judge instructed on that, but it wasn't charged. The jury had that crime before them when they considered this, and they rejected that crime and convicted him of touching himself in front of his granddaughter to arouse himself.
That doesn't answer my question, though. What's the distinction? What would be the distinction factually between the two crimes? What would make it? The judge said it was a lesser offense, whether it is lewd and lascivious behavior. Whether it is or not, let's not talk about that. But assuming it is, what would make the distinction between ag indecent liberties and lewd and lascivious behavior?
I don't believe lewd and lascivious requires touching.
Okay. So, in this case, if the jury believed that his pajamas just fell open, it would be lewd and lascivious behavior?
I think if the jury believed his pajamas just fell open, they would have found him not guilty. They believed it was an accident.
So the word exposed in the lewd and lascivious behavior instruction assumes there was no touching then?
I don't think it requires touching.
Publicly exposed his sex organ, which of course is a problem too because this isn't a public exposure claim, but they have to find that he publicly exposed his sex organ. Are you saying that it's the fact that he actually pulled out his penis that makes it aggravated indecent liberties as opposed to exposure?
I think that meets the touching requirement, and obviously the jury did.
And sorry, were you finished? It's the touching in addition to with intent to arouse or satisfy, is your position.
Right. And I don't know that it requires stroking but there was touching.
Well, the intent's the same with both charges, isn't it?
Yeah.
With the intent to arouse or gratify. You got to have that either way. So I'm just trying to make a distinction between how a defendant is, convicted of ag indecent liberties as opposed to lewd and lascivious behavior. I'm not sure I'm getting it other than the touching, which seems like it'd be required on the lewd and lascivious behavior charge too.
Well, the trench coat flasher doesn't require touching.
But the specific intent to which you refer, to arouse, that has to relate back to the touching rather than the exposure. And even if you accept that your theory of prosecution fits the statute, I guess I'm having a little trouble even being able to say it's a reasonable inference that the jury could have drawn that the touching, to which there's no evidence, but which you say must be common knowledge, must have had to touch it in order to expose it, that provided an inference that the touching was for the purpose of arousal, when it appears the way it played out, that if that is true, that everything happened that way, it was the exposure that was with the intent to arouse. You understand what I'm saying? Is you're saying he touched it in order to expose it, in order to arouse the little girl that was in the room, but the statute says the touching has to be with the intent to arouse.
The evidence was he did it to arouse himself, and what the jury obviously believed is he pulled his penis out in front of this little girl to arouse himself for his wife later on. That's what the evidence was.
So, as I understand Justice Johnson's questions, it's two inferences from the evidence. The first inference is that he did touch himself when he exposed himself.
Right.
And then the second inference would be that he did this in order to arouse himself.
Yeah, although the second item doesn't require inference. There was testimony to that, the fact that he did it to arouse himself.
Any further presentation, counsel?
I'll briefly address the prior crimes evidence. Without this prior crime, most likely this would never even have been reported. Okay? If a little girl tells her mother, says, I saw Granddad's penis, and he says, yeah, we were playing a game in the bedroom and it accidentally fell out. Without the prior crime, that probably never gets to the police department. And I understand we don't want to convict people because they've been convicted before, but at the same time, juries need the information they need to make a proper decision.
Yeah, in your brief on page 7, you do say, quote, it's unfair to expect the jury to decide this case without the knowledge that the defendant has been convicted of doing almost exactly the same thing with his own daughter, end quote. To me, that says it's unfair unless we provide the jury with propensity evidence that they need to know he did it before so they can decide he did it this time. And why isn't that traditionally, or at least at the time that this was tried, that was not permissible?
And any time you put on evidence of prior crimes or bad acts to prove a person committed a crime, you're putting on propensity evidence, and that's what it has to be. It was so similar, so much like this crime. It was necessary.
With respect to the denial of the continuance, my understanding is that the defense was concerned that it got 175 pages of discovery shortly before trial. We do have a statute, 223406, directs that a defendant has to have a reasonable time after arraignment to prepare for trial. So there is a statutory directive that you got to give the defense time to prepare. Ordinarily, what we're dealing with is, hey, you had months. Why didn't you go look at the file if it's an open file policy or whatever? Was this truly evidence that was not available till right before trial, or was there any fault in the defense counsel in not having access to it?
Well, the defendant sure would have known about the prior conviction and would have known about the child in need of care case. Now, whether they conveyed that to the defense, I don't know. The judge made a finding that we provided that material as soon as we got it. And of course, the defense took a hard line, insisted on either a continuance being charged to the state that would put us beyond speedy trial limit, or just order a dismissal. There would have been no surprise in this.
This, Mr. Warren received a hard 25 sentence, is that right? Are you comfortable with that based on what you've just represented to us, which is that there's no direct evidence, the little girl didn't testify, and even the officers didn't testify that he even touched his own penis, but that we can infer that he touched his penis when he removed it from his pajamas and exposed it to her, and that that's the total extent of the crime? And are you comfortable with that being sufficient for an aggravated indecent liberties charge for which he was given a hard 25 sentence?
I don't know that I'm comfortable with hard 25, period. Okay? That's the law.
Under the facts, that this was sufficient to impose that sentence?
Yeah, I mean, that's the law. Jury convicted him, that's the law.
Any further questions of counsel? Any further presentation?
No thanks. Thank you.
Counsel. Your 3 minutes.
I'd first like to address the assertion that in order for him to have exposed himself, he would have had to have touched himself in some way. If you look at page 11 of my brief, I give at least 3 examples in which exposure could have happened without any touching whatsoever. One of his statements to the police was that he was laying on the bed with his penis exposed when the little girl walked in. That's an example of exposure without touching. There was testimony that the fly of his pajama pants was exceptionally wide, and he could have moved in such a way that he exposed himself without touching. Additionally, using his trench coat flasher example, and if that's not actually touching, if he had just grabbed his pajama pants and pulled them down without actually touching his body, that would be exposure without touching. So it isn't a necessary conclusion that in order for him to have exposed himself, he had to have touched himself. And there was no
touchstone?
I'm sorry, I did not.
Is that the touchstone? You said a necessary conclusion. Isn't it the jury can draw reasonable inferences? And in your better argument,
the jury can draw reasonable inferences. I was countering his argument that he had to have touched himself in order to expose himself. My argument would, to your question, is that it's not a reasonable inference based upon the lack of evidence in this case. The second thing I wanted to touch on was Justice Moritz's question regarding the jury instruction on the lewd and lascivious behavior. And I was looking that up just as you were pointing out that the problem here is that it wasn't a public exposure. And I would agree that based upon the way that the lewd and lascivious was instructed to the jury, that it had to be a public exposure, that the facts presented in this case wouldn't be sufficient to establish that either. This was an exposure in his bedroom, in his house. He did not publicly expose his sex organ. As to the, just real briefly, as to the 6455 issue, I would agree that the reason that they admitted this was for the propensity. The state argued that the crimes were just so similar that that the prior crime had to come in, but that's not the case. The only of it, what actually came in at trial, was that Mr. Warren had previously molested his daughter. At the 6455 hearing, there was a little bit more detail as to what that included, which was touching, licking, and one other thing I can't remember off the top of my head, but it is in my brief, which goes way beyond the mere exposure. These crimes were not in no way similar. They were not so strikingly similar as to establish a plan. They were not so similar that it had to come in. And For the rest of the 6455 issue, I'll just refer you to my brief. If there are no other questions, I would just ask this court to reverse Mr. Warren's conviction of aggravated indecent liberties.
Any questions of counsel? Thank you. Thank you both for your arguments this morning. The court will take this matter under advisement.